My Lords, the application notice, the first application notice is where we should start on this run through the documents. And that is tab 3 of the bundle, page 130.
Page?
130. 130. And what we can all see what the application or the basis of it was, and over the page on 131 is the point about Lord Justice Flaux at 8. What level of judge does your hearing need? Justice of the Court of Appeal other than Flaux LJ, see skeleton. So just to make the point, and I think, my Lords, you have the point, that this is not an instance of 3 separate requests being made of Lord Justice Flaux to recuse himself. This is all one and the same, because it then throws us to the skeleton, and we should look at the skeleton, which begins at page 162 of the same tab in the bundle.
It's page 170, isn't it? So,
and it is, my Lord. It's just that, and my Lord, Lord Boss did indicate on the front of the skeleton, it does say, the appellant requests, with the greatest respect, that this application be determined by an LJ of appeal, other than Flaux LJ. And then at 170 to 171, that request is repeated, where it is respectfully submitted that it be appropriate for a Lord Justice of Appeal other than Lord Justice Flaux to deal with this matter. And that point about it being appropriate is in 24 and 26, the last line of paragraph 26 on page 171.
Is there any difference, and if so, what, between a request and an application?
Well, we would say yes, my Lord, very much so, because if we are met with an application, we can deal with it, the judge can deal with it, there is reasoned argument, and a decision is given, and one or other party can then appeal it. In this instance, to try and avoid giving evidence I would like to, but we are met with this. What are we to do with this? It's not an application that we can respond to. It's a request made, and we'll see what happens thereafter. But what it is not, with all due respect, my Lords, is an application, because as I say, if it's an application, it will be dealt with, and you'll have a reasoned judgment which parties can then appeal if they so wish.
What is the hallmark of an application?
It would be a Part 23 application for recusal.
The rules don't say all applications have to be made by Part 23 notice. By notice, sorry, it had to be. Part 23 is the part that deals with applications, but it doesn't have to say they all have to be made by a notice. I don't think.
Well, look, I assume your Lordship is right on that, but you would still have to pursue the application by some means. If you put, as we have here, a comment in a skeleton and a comment in the application notice under 5320, which is what the main application is, we would submit, and that is not then pursued in argument, as we'll come to.
Well, that's another matter. It's taken step by step.
Yeah.
And I mean, here it was pursued, and the judge said no.
Well, my Lord, let's just go through the documents on that, because
the judge directed that it be heard in front of him and gave directions for filing of skeletons.
Well, my Lord, we don't know, and this is a point my learned friends make, we don't know the process by which it came before Lord Justice Flaux, or he decided this matter, the extent to which.
Well, as you take us through, I think it's possible safely to infer the broad outlines of what happened. But perhaps, as you say, it's best to take them sequentially.
Well, we would say, but again, if at this stage, well, we're not even involved at this stage because we don't have sight of this document
quite.
at this stage. So there's nothing we can do about that at that point.
But in a sense, there's nothing you should do, because the rule does not contemplate you having any involvement. It's not like a permission to appeal. And therefore, it's really a matter between the applicant for under 5230 and the court,
Yes.
who hears it,
Yes.
or not hears it, sorry, who considers it. Anyway, that's the formal position, isn't it? It's only if permission is granted that you have a right to be heard.
On the 5230.
Yes, but this is a 5230.
Yeah. Well, there's I'm not sure, my lord, if that's quite correct. Under 6, it may well be we come in before that stage.
Because permission
yeah,
can't be
exactly
granted
wrong,
until
please
you've
say.
been served.
Correct, my lord. Yes.
What's the page of the response to this? Can we just go through the documents
Yes.
before we start debating all the nuances?
So the next document, my lord, is at page 177.
I mean, just for future reference, because it's too late now, if a case turns on who said what to whom at various different times, it is incredibly inconvenient for the court not to be provided with a chronological clip of correspondence electronically.
My lord, I would endorse that.
So can we just make sure that in future reference, your solicitors, who are all very large and resourced solicitors, do this? Because I've had tremendous trouble getting ready for this case. Over lunch, I had tremendous difficulty finding these documents. I'm still having that difficulty. I've seen the 3rd of October letter. I can't find it anymore. What page is it?
Well, my lord, it's the 1st of October.
1st
so
of October.
3 days after the
Can't find
28th. It's page 177.
Yes,
And you will see this is from my learned friend's solicitor, instructing solicitors to the court. And in the 3rd paragraph it says, whilst writing, could we respectfully remind the Court of Appeal that our client is seeking its application to be considered by a Lord or Lady Justice other than Lord Justice Flaux, and that then cross-refers to the skeleton. So that's, again, the request. That's the seeking of that its application to be considered by someone other than Lord Justice Flaux.
yes.
Now, ultimately, and just to address my Lord Underhill's point about, well, if this is an application, well, this could be an application. Well, if that is right, then the process would be that my learned friend should have appealed when they heard that Lord Justice Flaux was going to hear this matter. There shouldn't have been an appeal against that if there really was an
Well,
application.
let's just go through the.
Yeah.
Let's just go through the
Then,
documents.
my Lord, the next document, 178.
Yeah, and then they say this is the long-standing practice.
Yeah, and if the Lord or Lady Justice is of the opinion that he or she cannot fairly determine the application, it will be referred to another
Right.
judge.
Can I just say, in relation to this, that we would appreciate any submissions the parties wish to make as to whether this is an appropriate practice, because it is possible in our judgments we will say something about it.
Well,
No, you don't have to answer now, but just give it thought whilst you're going on, and Mr. McGrath will do the same. Okay, keep going. So we know
And
what
then-
the practice is, because we've...
179.
Sorry, just to spell it out, the practice is not Lord Justice Flaux will decide it. The practice is Lord Justice Flaux will, if he is of the opinion he cannot fairly determine the application, it will be referred to another judge.
Yes. That's the practice. And it's the practice that I think both parties have accepted, with all due respect, is known to be the practice, and it was we would say, a fair practice. Then 179, it's an important response from Hugh Cartwright again, in responding to that email we've just looked at. We thank the court for its email and note the position. Our client will, of course, respect the decision of whichever Lord or Lady Justice of Appeal is asked to determine our client's application.
Do they think it's an application?
Well, no, I think to determine our client's application is the 5230 application.
Well, that's not clear, actually.
Well, with respect, my lord, I would say that it is clear. The only application that we have is the 5230, and the point that is being made is that the Court of Appeal would have assigned it, obviously, to the judge who originally, or provide it to the judge who made the decision on the PTA, and it will be their decision as to whether or not they will determine the application. And then in this email, they are talking about that application, i.e. the person who's going to determine the 5230.
They probably are, but it's a relatively confusing. What they're doing is being deferential to the court and saying, obviously, we're not. If it's decided that it'll be, if it is decided that it be Lord Justice Flaux, we will abide by that decision. But you could read into it, but we still say it shouldn't be. And we don't assume it has been decided yet, because what you say in your standard practice email is that it will be for Justice Flaux to decide whether
but the key point, my lord, would be that if one reads this, then they are accepting that if it is decided that it's Lord Justice Flaux, we will abide by that.
Well, yes, of course, but well, let's keep going.
And so that's 5th of October. Then the 3rd of November is page 180.
Yes, 3rd of November. Next page. Yeah.
Page 180. This is from the Court of Appeal. Lord Justice Flaux has directed that the application for permission to reopen shall be listed at an oral hearing before him on notice to ourselves.
So why is that not the decision?
The decision in respect of which?
Of recusal.
Well, my lord, if one reads that as being a decision on recusal, the appropriate course for my learned friends then would be to appeal it, if they're unhappy about it.
Appeal it to whom?
Well, they could appeal it to the Supreme Court.
No, they
Well,
can't.
if it would be an issue of apparent bias, if the basis of this is apparent bias,
I mean, I respectfully doubt whether they could appeal it to the Supreme Court. They can only appeal final orders of the Court of Appeal to the Supreme Court.
or well, to
They could ask that Lord Justice Flaux. But they could ask. They could try and appeal it to the full court. How they'd get on, I'm afraid I don't know without scouring the rules. But my lord will know better than me.
Well, I would have to check myself.
Well, I think
the general.
there is provision in 52 for,
Yes.
for review of a decision by a single LJ.
Yeah,
That's
there
just
is,
what I was
isn't
to say. Yes, that,
Yeah.
it was. I forget where it is, but it's one of them, 52. So they could have asked for it to be reconsidered by the full court.
Which is the rule?
Find it in a moment.
Just trying to find it.
It might be a 5224, but I'll check.
I think it is, my lord.
That's about court officers.
Yes.
Any party may
22,
request
24,
the decision of a court officer to be reviewed by the single judge. The party may request under 6 a decision of a single judge made without a hearing to be reconsidered by the same or another judge. Single judge may refer. It's a bit complicated. Anyway, they could have done something, and they didn't do anything.
And they didn't do anything, my lord. And it's noticeable that, and obviously we then attend in front of Lord Justice Flow. There's no argument on the point. There's never been an argument addressed on the basis of apparent bias either, even in the original skeleton. There's no reference to apparent bias on the part of Lord Justice Flow there that would justify a case of recusal.
But they never withdrew the skeleton.
They didn't, my lord. That's fair to say, but they didn't pursue it at all. And it wasn't a live issue. It certainly wasn't a live issue on this side of the court. And we just assumed that they were content with Lord Justice Flow dealing with it. And if we look at what I'd like next to show you is what they say in their skeleton for this application in relation to this point, which, so that is basically the run through of the documents.
Right.
And then if we go to tab 4 of the appeal bundle, page 338, and my lord, if we start at paragraph 49, because this highlights part of the problem here, that the reasons and authority in support of requesting Lord Justice Flow's recusal do not appear to have been considered when refusing the requests. Rather, the response from the Court of Appeal Office appears to have been a copy-paste standard response, as is seen from the different colour font on the email. Alternatively, it could simply have been a cut and paste of an email from Lord Justice Flow. Either is regrettable, and the court, and had the court properly been constituted by another Lord or Lady Justice, it is likely, or at least possible, that the manifest error of law and justice done would have been avoided.
But
now,
this may not be your point, but just so as to get this analytically clear, it doesn't look as though they're quite focusing on the right decision. The decision is not taken by the cut and paste response. The decision is taken subsequently when Lord Justice Flow decides to hear it himself.
and this is what that's part of one of the points. They don't regard that decision as a decision such as your lordships, or they don't regard their original skeleton as being an application, number one, which was dealt with by Lord Justice Flow by making that order that direction in the 3rd of November email. That's number one. But number two, these points about, well, it's unclear what has happened, all stems from the very fact that there hasn't been a proper application, which the parties have argued about why Lord Justice Flow should recuse himself. And Lord Justice Flow has given a reasoned judgment whereby he explains why he feels it's not appropriate to recuse himself.
Well, is that right? The skeleton succinctly, but absolutely explicitly, says he should not hear it and gives reasons. You may be right, Lord Justice Flow hasn't given a reasoned answer to those reasons when deciding he'll hear it himself. But that's hardly a criticism of the claimants, if anything, in all respect to Lord Justice Flaux, it's a criticism of him.
Well, with respect, my lord, at the time of, it comes back to the point that I'm making to you, that that is not a proper application. And maybe you...
Just remind me again what you say they should have done.
Well, we say they should have made a formal application, certainly as soon as they knew on the 3rd of November, which before then, this matter was not necessarily going to be dealt with by Lord Justice Flaux. 3rd of November, they are told Lord Justice Flaux is going to be dealing with this. It's at that stage, if they were upset about the fact that Lord Justice Flaux was going to be dealing with it, they should have made a proper application.
What application would that have been?
For him to recuse himself.
Well, he's already decided not to. So it would have to be an application for him to reconsider.
Well, it would be an application, in which they could make proper representations orally to him.
Well, that's all by the by. I'm just trying to understand what the formal application would have been. Am I right in saying that since he had made a decision on, though not before, the 3rd of November, to hear it himself, thereby, by necessary implication, refusing their application or their request that he didn't do so, that decision, they should have asked for a reconsideration. Is that it?
My lord, yes.
I mean, that's possible that he could have asked for reconsideration, but it might have been met with a dusty answer, because a party may request the decision of a single judge made without a hearing to be reconsidered, and the reconsideration will be determined by the same or another judge on paper without an oral hearing. Under Order Part 52.24.6. So they could have done that, but they might have thought it was a bit of a waste of time, and they might have thought, well, we just got to go through it and see what happens, and then appeal his decision on the grounds he ought to have recused himself.
Well, my lord, at that stage, with all due respect, maybe the application, the 5230 application had been presented in front of Lord Justice Flaux. Whether he's actually read the full skeleton, nobody just know.
You can't take that point. The presumption must be, and frankly, I would have thought the near certainty that he will have seen the application notice and skeleton argument. Whether or not he actually did, I can't see any reason why he wouldn't have.
If he did, you're digging yourself an even bigger hole, because he hasn't read the right papers.
Would I see that? But the point is that having left it on the basis that we will abide by whatever decision the Court of Appeal might make, which is what they have said, and then they are told that it is Lord Justice Flaux who will be hearing. With all due respect, if they were unhappy about that, there is the ability and we would say the obligation of them to pursue that and say to Lord Justice Flaux, once they know he is going to be hearing it, that he should recuse himself in terms.
Well, let's assume that you're right, and they could procedurally have done more than they did. Why, when we're in a slightly shadowy procedural situation, is it not reasonable for them to say, well, we're going to see what happens at the hearing, he's made his decision, we can make whatever application we could have made later if it doesn't go our way at the hearing, because it is, maybe they would have thought, well, it's final under 5230, so when he makes a decision under 5230, we can't raise this. But I mean, they are in a slightly difficult position. And what I'm asking really is why, when a party is in that difficult position, are you entitled to say they are absolutely prohibited from ever raising recusal again?
Well, with respect, my lord, to what parties are not entitled to do, we would say, and I'll show you the Lockerbell case in a moment on that, is to do exactly what they did do, which is to know that they could make an application to Lord Justice Flaux to recuse himself, choose not to do so, let's see how the hearing goes, and then when they find out, oh, it's not gone right for us, we then raise it by reference to another 5230 application.
Well, on one analysis, they had applied and been refused. So does Lockerbell say you can't do that? Afterwards, you can't carry on.
Well, Lord, you have my submission.
Where's Lockerbell? Show us Lockerbell.
My lord, it is tab 5 of the authorities.
Which page in Lockerbell?
And to begin with, page 163, 164. Is my Lord Bingham. Oh, well, maybe just at the very bottom of 163, at the end of paragraph 25, we repeat, every application must be decided on the facts and circumstances of the individual case. The greater the passage of time between the event relied on as showing a danger of bias.
I'm sorry, I've lost where you're reading from.
It's the very last 4 or 5 lines at the bottom.
Yes.
The greater the passage of time between the event relied on as showing a danger of bias, and the case in which the objection is raised, the weaker the objection will be. And then over the page 26, after the where it says, we do not consider the waiver in this context raise special problems. After the authorities, it says, if appropriate disclosure having been made by the judge, a party raises no objection to the judge, hearing or continuing to hear a case, that party cannot thereafter complain of the matter disclosed as giving rise to a real danger of bias. It would be unjust to the other party and undermine both the reality and the appearance of justice to allow him to do so. Now, my lord, it is, and I take the point that at the original stage, well, maybe, actually, can I just go on to read 68 and 69, which is pages 173 to 174.
Yes.
It says, in our judgment, Mrs. Emanuel and her lawyers had to decide what they wanted to do on the 28th of October. They could have asked for time to consider the position. They could have asked the deputy judge to recuse himself and order the proceedings to be started again before another judge. In the event they did nothing, in doing nothing they were treating the disclosure as being of no importance.
This is the case where Mr. Collins didn't recuse himself, although Herbert Smith had been acting for one of the parties.
Correct, my lord, yes. And if we look at paragraph 69, just above D, we are concerned only with the complaint. Do you, lordships, have that sentence? Yeah. Based upon an appearance of bias allegedly produced by Herbert Smith's involvement in the litigation. This involvement was, in its essentials, disclosed on 28th of October. It was not open to Mrs. Emanuel to wait and see how her claims in the Lockerbell litigation turned out before pursuing her complaint of bias. Mrs. Williamson protested on the 28th, not enough was disclosed to put her to her election. We disagree. Essentials of the conflict of interest case that is now relied on were to be found in the press cuttings. Mrs. Emanuel wanted to have the best of both worlds. The law will not allow her to do so. Now, my lords, we rely upon that sentiment, which is exactly what we have here, that they were trying to have the best of both worlds.
It's not what has happened here. Crucial difference is that they did make an application and had a decision on it. They didn't challenge the decision. Whereas both the general remarks which you rely on in Lockerbell and the facts of the particular case involving Mr. Collins were cases where they never made an application after knowing that they had grounds to do so.
Well,
And the same is true of Baker.
yeah, my lord, yes, but the 2 points I wanted to leave. Firstly, the appeal route, which they could, and we say should have done, if this was truly an application. I've got my submissions that we don't necessarily accept that there was an application, there was a request. But the other thing is the injustice to me as the other party. Now, I take the point, my lord, that when they first raised this request, I wasn't involved, my clients weren't involved in that process. But by the time of the hearing, we are very much involved. And the consequences to us now are that because that point was not raised in front of Lord Justice Flaux, giving us an opportunity to comment on it, maybe we would have said, my lord, yes, you should recuse yourself. Maybe we would have said no for these reasons.
But you're benefited by the fact that you had a decision in your effective favour.
Well, my lord, I'm
The
not...
judge made a decision. I mean, unfortunately, parties are not asked sometimes when the judge is going to decide in their favour. So if party A makes an application affecting party B, and the judge decides to dismiss the application of party B, benefiting party... Sorry, dismiss the application of party A, benefiting party B, judges sometimes don't ask you. So, I mean, that may be bad luck.
Well, my lord, it is, but it may have benefited us now, but we are now back here.
Well, of course.
You know, and because...
Because of injustice, if they're right. And if
Well,
they're not right,
with
then
respect,
you'll be okay.
because they never raised... We say they should have raised the issue of recusal in front of Lord Justice Flaux.
Well, they did raise it in their application. Can I just pursue this a little bit further? Let us suppose that a party objects on good grounds to a particular judge from hearing the case, and the judge refuses to recuse himself, let us suppose. The logic of your argument is that that refusal must be immediately appealed, because if the party asking for recusal then participates in the hearing, he somehow lost the right to object to the judge having refused to recuse himself. I think that must be the logic of what you're saying, because they made their, let's call it a request, let's not get into arguments about application, they asked, and they gave reasons why they didn't want Lord Justice Flaux to hear the application, but he did.
Well, my lord, that may be a timing issue, in a sense that if it's done at the actual hearing, and the decision goes against you, you say, well, either you can expressly reserve your position, or you can say, well, I want to appeal that decision, and there will be an adjournment or whatever. But in a situation where you've got the notification that Lord Justice Flaux is going to hear this on the 3rd of November, they have plenty of time to take that issue forward. Now, my lords, I fear I will be going round in circles if we stay on that issue, the recusal principle and what happened in that, on the facts of that issue. I did have some comments to make about the test for apparent bias and the factors that one would take into account, because that's relevant, obviously, at the next level of the debate is whether or not it was right that his lordship should have recused himself, which is a different issue. And I'm sure your lordships are well aware of what the test from Porter and McGill is on apparent bias. The basic test is of whether a fair-minded and informed observer having considered the facts, would conclude that there was a real possibility of bias. Now, the Court of Appeal, this court in Bubbles and Wine Limited, Lord Justice Leggett, as he then was, has given us some direction as regards the matters that you should and could take into account in whether or not the fair-minded and informed observer would consider apparent bias being prevalent in a particular case. And I wonder if I could just show you what is said in that decision. The Bubbles decision is of the Authorities Bundle, tab 25. And the page I would like to take you to is 657. And it's paragraphs 17 on that page, and then over to page paragraph 19 on the following page. Just invite your lordships perhaps to look at those paragraphs quickly.
Which paragraphs?
Paragraph 17 and 3 to 19.
What about the fair-minded observer not being unduly sensitive or suspicious, nor complacent? Intense focus on the essential facts of the case. I mean, how does that?
Well, my Lord, I'm just giving you the how you approach it as a fair-minded and informed observer. But the
For good or ill, Mr. Davies, judges all consider themselves to be fair-minded and think they know that they should give anxious scrutiny to the cases before them.
My Lord, I'm obliged for that. And the point I really wanted to get from what Lord Justice Leggett is saying here is at paragraph 17, where he defines bias, where he says bias means a prejudice against one party or its case for reasons unconnected with the legal or factual merits of the case. So
is that really a definition of bias?
That was the definition of what the lordships in this case have adopted, is what the Supreme Court has assumed.
In the Seraphim case, they didn't decide.
They didn't decide it, my Lord, that's correct. But that's the nature of what we are talking about with regard to bias, which obviously is what apparent bias is. It's just apparent, but it's the same test. But what it is requiring is some form of animus towards the individual who is making the complaint.
Well, isn't the more important part of that sentence, the first part, the court has to ask whether the circumstances it's found would lead a fair-minded and informed observer to conclude there was a real possibility that the judge was biased. You don't need a definition of bias in order to do that. It's not bias about a particular fact or circumstance. Bias means bias. It's a perfectly common English word in favour of the other side in this case.
Yeah, my Lord, but the point I'm trying to make is a bias against the party.
Yes, but the really important part is, would it lead a fair-minded and informed observer? In other words, it's an objective test.
Correct, my Lord. And I don't dissent from that. I'm just showing you where one gets the test from.
Yes.
And what one will see, and the type of instance that you will take into account in reaching that view is the fact that, for example, a Lord Justice of Appeal will ordinarily be asked to determine a 5230 application if they've done the permission to appeal application. That's something that they would be aware, the fair-minded, informed observer would be aware of. It's a practice that is not to be shunned, it's not to be frowned upon. And this is a point that was made at some length in the Brugal case, which is, I don't want to take up undue time going through that decision, but I do wish your lordships to be aware of what is said in it, and it's at tab 26 of the authorities bundle. And it is dealing with this, the issue of, well, how would a fair-minded observer regard the fact that the Lord Justice of Appeal, for example, who makes a decision on a permission to appeal, is then part of the final appeal hearing if they'd originally refused permission to appeal.
But actually, Brewer was a single judge.
Yes, my lord. Yes. So if the single judge refuses permission, that judge is then asked to sit on the main appeal.
As a single judge?
No, as part of a...
No, as a single judge. It was Judge Borcher sitting in the county court as a single judge on appeal. That's why I gave permission, because I wanted to know whether the same principle applied to a single judge hearing the appeal as did to a panel of 3 judges hearing the appeal. And this court said yes, the same principle.
Yes, sorry, sorry, you're ahead of me, my lord, in the sense of that's the principle I wanted to get across. And the other point that comes through from that decision, which is comments at length on the Sengupta case, is the importance of the oral argument of counsel. So, in a situation in which the fair-minded observer knows that a judge, like in this instance, Lord Justice Flaux has decided the permission to appeal against my learned friend's clients, but then knows that there's going to be an oral argument down the line, which he has ordered, that is a very powerful factor in support of, we would say, our position, that the well-informed, fair-minded, informed observer would see that as indicating that the judge would be approaching this with an open mind, because he's going to sit and listen to the argument. And that is an important point in this case.
I mean, what you have to answer is the point that Mr. McGrath made, which is that's all well and fine in the situation where the judge is hearing an application on paper and then hears a renewed oral application, same judge, where the allegation is not that he's done something wrong, but that their further arguments should be taken into account. But it's not applicable in a 5230 where the judge is alleged to have followed a procedure which is unfair, positively, in 3 or 4 respects, to the applicant. There, the reasonably informed observer would think that the judge might be, I've forgotten, reasonable possibility that he might be biased. It's a completely different situation, these cases, of the previous practice of restoring.
Well, with respect, my lord, I would say no, it's not, in the sense that it's still a 52, any 5230.
This is not a 5230, is it?
Well, no, but I'm talking about our present case. You were postulating to me the position in this case, that you would have a different attitude in relation to determining has the integrity of the process been critically undermined question. You'd apply a different test to that which you'd apply to the merits test. So if the permission to appeal has been refused, and the other side make a 5230 application. The ordinary course would be it's for the judge who made the original decision to determine it. And the point I was going to make is that on a 5230 application, you are generally going to have an assertion, or you are always going to have an assertion, that the integrity of the process has been critically undermined.
But there are different ways that could happen. Go back to the paradigm case. You apply under 5230 because you say the judge wasn't given the right papers. There's no criticism of the judge. He didn't have the right papers. And you say, well, I didn't have the right papers, so I'll reopen it and think about it again. Or I wasn't told some particular fact, which is very important. But here, the criticism is, you, judge, devised a procedure that was not mandated by the rules and is unfair, so that, to use Mr. McGrath's awful phrase, the judge had skin in the game.
Well, I'll come back to that. I understand the different factual scenarios in play, my lord. I would take issue with the fact that this was a procedure devised by the judge. It was a procedure that was presented to the judge by the parties, and he made his decision as a result of that. It's not for the judge, as I will come on to say, it's not to criticise the judge for what took place in this instance. It's not his fault.
I mean, you say that, Mr. Davies, but at some point the judge, just standing back from all the detail, at some point the judge was asked, do you want to sit on this case or not? And he had to consider fairly and justly whether the rules of natural justice allowed him to do so. And he knew at that stage that it was being said that he had refused submissions, which would have made a difference to his decision, that he'd got the decision on Marex wrong, having been very involved in Marex all the way along the line, and he knew that he had put them on very strict deadline for making an application, and that they were upset about all the above. So he wasn't in any doubt about that. And so you say, do you, that in that situation it's perfectly reasonable, I mean you have to say, I think it's perfectly reasonable for the judge to say, look, this is a routine 5230. Don't you think that the judge might have thought, look, it's really sort of an attack on what I did before in the second PTA and in the, I should really get somebody else to look at it.
Well,
probably make the same decision. I mean, wouldn't most judges do that? That's what I'm asking.
my lord, I can't answer for.
No, you can't answer
judges,
for judges.
but
what do you think?
my submission to that would be that on the Marex situation, he was probably the best judge to have to deal with that issue. He knew the issues and what the Supreme Court decision meant. So there can be no complaint, with all due respect, about him taking that.
Yeah, okay, we'll leave Marex.
So, on the integrity point, just to pick up on the criticisms that were made about, again, all the rehash arguments that were presented to Lord Justice Flaux about the 335 point. The fact of the matter is that was a different point to what we call the natural justice point. That point was whether or not he had made a decision off his own back.
It was sort of intertwined, there, wasn't it?
Well,
because it was a decision off his own back if he had wrongly refused submissions, and not if not. So the two was connected. The two were connected.
Well,
weren't they?
Well, I think one has to take it in stages, in the sense that leave us up the nut, because it is a completely different argument, whether or not there's been a breach of natural justice in not giving Nectrus an opportunity to put in further submissions. That's that issue. But whether he made a decision without the parties having addressed him on the point is a completely different issue.
Well, of course it's different, But all I'm asking really is, you say, and I get the submission, what he did was unexceptional and entirely comparable to the cases where you renew an application that was dealt with on paper. And you have to say that.
Well, I have to. Maybe I do have to say it, my lord, but I say it because we say it's right.
Yeah.
And you cannot divorce that from. My learned friend tries to look forward into the future to rely on matters to say, oh well, this will buttress my case on what the well-informed observer how he would view or she would view what took place. By the same token, we have here Lord Justice Flaux saying, well, you can have your oral argument.
Is it really any more? I mean, this case seems to me to be boiling down to quite a simple question for the court. Would the fair-minded and informed observer think that there was a reasonable possibility that the judge was biased if he heard the 5230 knowing that he was going to be, that the allegations were that he had refused to allow them to make a 335 and not directed any submissions on the second PTA application. And you say absolutely not, and Mr. McGrath says it really was quite serious. He knew how important it was to us. We'd said it several times in the skeleton and so on, and he should have recused himself. And that's really what this case boils down to. I mean, the Marex thing, in a way, is the second stage, mostly, and the way he dealt with the argument orally is also, at the very most, a sort of told-you-so point. It's really those two questions. Well, the single question.
Well, I see your lordship takes the middle point. I say I've got two further points on either side. We say it was too late for it's too late now for them to take the recusal.
No, I understand.
You've got that. And I hear what your lordships have been saying to me on that point.
No, but
and even if I'm wrong on the middle point that we've just been debating, my position would be, well, you still then have to go on to look at the procedure that was adopted and say, well, did that critically undermine the process of justice by his lordship making the decision on the PTA, having had the parties' submissions on the Supreme Court case.
Do you have to go that far? Because surely the recusal, if he should have recused himself under 5230, then it's as if no 5230 has happened before. So you then have to look at whether the justice was undermined, but it was undermined because the hearing went ahead with a judge who ought to have recused himself.
Well, we're put.
So that's why the PTA point comes in at the first stage, but not the second. Once you've decided the recusal, you're there. Then the next question is under 5230, the new 5230. Do they satisfy the criteria?
Yeah, well, I think that's the point I was trying to make. I hope not at cross purposes. So for your lordships would have to then look at the process by which he reached his PTA, because that's what they're attacking. Assuming.
No, I think we are at cross purposes. Let me explain, because I think it's quite important. What I'm putting to you is that the core question is, would the reasonable and fair-minded observer think that the judge who was being attacked for refusing the 3.3 and not allowing submissions on the PTA it was a reasonable possibility he'd be biased. Now, if so, then he should have recused himself. If he should have recused himself, then there was a challenge to the judge. There was an unjust process of the first 5230. So it's as if there wasn't a 5230, we move directly to considering whether the requirements for 5230 are satisfied on the basis that the original 5230 should not have gone ahead.
So, yeah, so we're now back at,
We're now back at 5231 and 5236.
correct, well, that's, yes. Which is why I say that you would then, I think I'm right in saying that you would have to then consider,
And you say then delay, and you say, well, you say a lot of things.
well, I do say a lot of things, my lord, but the important point is that you can't lose sight of the fact, effectively you are back in the position as if you got the permission to appeal refused,
Yeah.
and then we have the 52, we're in now the 5230 position. So the first question is the process by which His Lordship refused permission such as to critically undermine the procedure? That's the issue. So that means you then look at, well, how did that permission...
Essentially, we are in the position, you say, that any one of us would have been if we'd stood in the shoes of Lord Justice Flaux.
Correct.
Yeah.
Yes.
And at
So
that
we have to
stage, does
decide all the things
5218 come into play?
Well, we would say no.
Because?
Well, number one, it hasn't been raised by the other side, and we would say that the original, well, there are two answers, that the original decision of His Lordship whereby we call it contingent permission to appeal was given, that is not permission to appeal. It's a matter of construction. There just isn't, there is no permission to appeal at that stage. It is dependent. What he's effectively done is to say, well, I'm holding my pen until the Supreme Court case comes out.
But you say that's what he's effectively done, but that is not what he has formally done. You have to look at the order.
Well, there is no unconditional permission to appeal.
No, there is. I mean, that's the whole point. I'm sorry, Mr. Davies. I was thinking about your, I think, important submission that we then have to look at 5230, assuming that there's just a whole gap in the history and that we are in the position of Lord Justice Flaux on the January 2021. But we'll come back to that. But the order gives permission to appeal and then says it's in a sense contingent, because I want to see it again. But it doesn't give conditional permission to appeal, as my Lord said very clearly earlier this morning.
Well,
Do you disagree with that?
well, I would say that well, neither party felt that there was permission to appeal certainly until the Supreme Court decision had come out and the parties made whatever representations they
Well, I think you're not reading it correctly. Which page is it on?
118.
You see, I think if you go to 118, it says, we do these things all day long, so we sort of know. It says, decision, permission to appeal allowed on ground 2, but see reasons and direction. So that's the decision, permission to appeal allowed, and then the directions simply say that, and make it clear. So it seems appropriate to grant permission on the contingent basis that matters refer back to me when the Supreme Court comes out. So that's not really a contingency. There's no such thing as contingent permission to appeal. He wants to give further directions when it comes out, and he says the terms further consideration. But he's allowed to say that.
Well, I would say, my lord, with respect, we're talking semantics here, in that that is a conditional permission to appeal, I would submit. That's my...
Conditional on what?
Well, on him, on the Supreme Court decision in Marex, and
How can
the
it be?
review
There may
of
never be a Supreme Court decision. I mean, we've all known cases which settle immediately before the judge delivers their judgment. sensible judges sometimes say, I'm going to deliver it anyway, but could have happened the other way.
With respect, my lord, I would read that, well, one knew that the arguments had been gone through at that stage and we were just waiting the judgments, and the correct construction of that decision and reasons taken together, in respect, we would say, amounts to a contingent granting of permission.
Well, the contingent, I suspect he chose that word accurately. Even so, I think it gives rise to difficulties. But he didn't say conditional, because conditional grant of appeal means something under the rules. It's 52.6. This was not a conditional grant of appeal in that sense. It was an absolute grant of appeal. It was contingent in the sense that he had flagged up that he might entertain an application to set it aside, revoke it. I forget, we have a look at 52.18, but that's what the words, that's the effect of them. In the light of what the Supreme Court might say in Marex. And in principle, he could do that, I think, of his own motion or on application by the parties. But we've all been talking about 52.18, I don't think we've actually looked at it, but that's the substance of it. And that's the only procedural way in which you can make sense of this, isn't it?
Well, my lord,
Or it makes sense, that's a hard way of putting it. It would give effect to the intention.
well, assume your lordship is right on that basis, that we are thrown to 52.18. Well, that is precisely what has happened here, because there is a compelling reason, because we've had the Supreme Court decision.
Yes.
And so there's really not a major issue procedurally. I appreciate my letter of July didn't expressly refer to 52.18, but that is the impact of it.
No, you say, I mean, I understand what you say. You say that's a clever dick point raised by the court. Of course they decided it was a compelling reason or he wouldn't have done it. And the fact that they didn't refer to it, if that invalidated the decision, then lots of things would invalidate decisions. I mean, I sort of take that point, Mr. Davies. I think if that were the only point, it wouldn't be a particularly good one. I just am slightly keen on precision.
My lord, I can
And
see
call me
that.
an old judge if you want.
But the importance of the 52.18 point is once one has, as the Lord says, which one formally must understand what is happening, a decision is being made to set aside a previously granted permission. 52.18 doesn't say in terms that could be done on application by a party or by the judge. In principle, it can be. I thought it could be done by either route. But in either case, it's crucial that there be the opportunity to grant, to make representations for the affected parties. And if that had been focused on, the judge might not have thought it appropriate to reach the decision he did about whether your letter constituted a proper opportunity to make representations.
My lord,
Their letter.
Sorry.
and well, that then throws us back, my lord, to the process that reached the conclusion with his lordship's decision to say permission to appeal is refused. And it's important to see how that came about. I appreciate the analysis that we're now looking at via 52.18, but whether that process was critically undermined is important for your lordships to have in mind how that came about, because it's been somewhat thrown from the other side that the blame all lies with the court for failing to give directions. Well, with all due respect, that is an unfair characterisation of what the position should be, and the court is not obliged to give directions in this particular instance at all. We start off with the decision that we have here at page 118,
think they say the court is obliged to give directions. I think they say the court is obliged not to decide the case without hearing submissions.
Well, well, that's what I will now just run through with your lordships on. If I may. I just want to make sure I've got the right page references before I start doing this with your lordship. And what we have, obviously we have, excuse me, comes about, my lord, of not having a chronological bundle which your lordships were abhorring.
What are you looking for?
Sorry, forgive me, my lords, I can't find the document I wanted to find.
What document is it?
It's the document whereby the court, where the parties, in light of the order of his lordship, had asked or were told that they were given liberty to apply.
Page 120.
Of June.
My lords, yeah, thank you. The 5th of June.
That's a slightly different point, isn't it?
Well, this is what the position is. So we have the decision of his lordship that we've just been looking at, and then there was discussion about our own appeal and how that should be handled, whether it should be stayed. And solicitors from my learned friends get in touch with court, talking about the contingent permission to appeal granted by the Court of Appeal to their client.
We can take this more shortly, aren't you? You simply say, the judge has made this order, we're all therefore waiting for Marex. Can we please have nothing, all procedural steps deferred in the meantime? Isn't that the point?
Yeah, and it was.
Yeah, and the office replies. Well, the case lawyers made the decision that any further steps are deferred, pending judgment of the Supreme Court. Liberty to both parties to apply. What do you get out of that?
Well, just that is the position as it was left, and then we have the letters that come from the parties. First of all, we have the Hugh Cartwright letter, which you were showing this morning.
Yeah, those are 87 and
87 to 88. And you have Scadden's response of 90 to 91, setting out our respective positions. And in what we don't have is, after our letter, first of all, we don't have a suggestion that they want more time to put in further submissions. There's no response to our letter of the 21st of July saying they want to put in further submissions. The matter is left with the learned judge. On that basis, he is presented by the parties with a process that they themselves have adopted. And my learned friend says, oh, well, maybe our letter was poorly drafted and it didn't say everything that we now want it to have said. But the learned judge is not a mind reader, to be fair to him. He can only act on what he is told by the parties. And they never did say, although my learned friend tries to read it into there, that if the court is minded to refuse permission to appeal, then they would wish to put in a further skeleton. This is a permission to appeal stage. They've already
The problem as I see it is that if, I mean, I take all those points, I may say so, they're well made, and the letter's hopeless, right? But the problem is that it's not their application. The problem is that on any proper analysis, which was not undertaken by anybody I know, this is a grant of permission to appeal, where the other side should be applying to set aside the grant on the basis of Marex, and the Nectrus should be resisting that. So the cart has been placed before the horse by this letter, and the judge looking at it, I'm afraid, might be said to have dropped the ball by not realising that what he was dealing with was an application. This is perhaps where 5218 comes in, where he was dealing with an application under 5218 or anyway 52.6 to drop a condition or revoke permission. I mean, it's a serious application because a permission to appeal obviously gives you the leeway to get on and run the appeal and win. Doing away with that permission to appeal, in this case, is worth some millions of dollars. So it's a serious application, and it's one that you had to make, or would wanted to make, as appears from your 21st of July letter, which says we want you to revoke the permission. So that's where it all went wrong, didn't it?
Well, my lord, if it did go wrong, it went wrong via my learned friend. It's not the judge's fault.
Is it a question of fault?
Well, whether it's a question of fault or not, but it is starting off with my learned friends adopting that position, and we follow suit. And whether our letter went first or their letter went first, with respect, doesn't matter. I mean, both parties have submitted what they wanted to say on Marex. And
But if the question before Lord Justice Flaux was governed by 5218, and nobody referred him to the very rule which dealt with what he had to consider, why isn't that corrupting the process? Well, for whatever reason,
well, because
just as much as not reading the right papers corrupts the process.
well, because my lord, I don't want to say a clever dick point, but the substance of the point is there, in the sense that the issue is, well, is there a compelling reason to withdraw that permission to appeal? So whether it actually says 5218 in either of the letters, and whose letter comes first or second, with respect, doesn't matter.
So you would say that since Lord Justice Flaux said that the ground was unarguable, that of itself is a compelling reason?
My lord, yes, in the light of the Supreme Court decision. And in light of the fact that my learned friends don't write after our letter and say, well, hang on a minute, this is a 5218 situation and we need this, or we want to make further submissions, or you shouldn't do X without us doing Y. It's not the judge's fault, or we would say the process is not critically undermined because we've ended up at the same point. I mean, the fact of the matter is, even having heard oral argument at length and had a further lengthy submission in writing from the other side on the Marex point, his lordship reached the decision that he reached, which is a perfectly well-reasoned decision. Now, that may be capable of being questioned by reference to Primio now, but his decision at the time, we submit, was correct.
But that's not really the question, is it? The first question is whether the process has been undermined. If yes, then we have to consider whether there's a real prospect of success, and that's now. So Primio has been decided. So that's all very unfortunate for you, because you would say, well, if it had all happened differently and the judge ought not to have had to recuse himself and it had all been decided earlier, Primio wouldn't have happened, and therefore the whole outcome might be different. But that is not the correct analysis. The correct analysis is on the premise that we've debated. We are now deciding at 52:30, and we have to decide whether the process was fatally undermined. If it was, we have to decide if now there is a reasonable, real prospect of the case.
My Lord, I'm not going to stand here and say that if you get to that stage, then you've got to turn
You don't
the clock
disagree
back.
with that, no?
I'm not going to say that you have to look at the Marex reflective loss issue by reference to the law.
We don't have to close our eyes to what has happened.
Well, I think I'd be rather unrealistic.
Would.
If I was to
Speaking for myself, even without Primio in the Supreme Court, I might be inclined to think there was an arguable point here. Of course, it would be much less obvious, because the Court of Appeal of Cayman Islands have gone the other way. But still, that we needn't go there.
Well, your Lordship didn't have the benefit of my submissions.
No, well, that would have made all the difference. You're quite right.
Well, oral submissions do make a difference, as we all know, and which is why I come back to that factor on the issue of what the independent observer would view of the process when he knows, or she knows, that there is going to be an oral hearing of the complaints that my own friends make against Lord Justice Flaux, and to say that he would not, or no fair-minded observer, informed observer, would take the view that Lord Justice Flaux would not come to this court and deal with that application with an open mind. With all due respect, we would say they wouldn't say that. If they know there is going to be an oral hearing of it to test those very issues, even though the process with which he was involved.
Are you not, I mean, by saying all that, I mean, I totally understand where you're coming from, and I think one would say, you know, Lord Justice Flaux is known to us all as a fair-minded judge, and therefore, if you were a fair-minded, informed observer with a judicial appointment who knew Mr. Justice, Lord Justice Flaux, actually, Mr. Justice, then Lord Justice, and Chancellor Flaux, absolutely, you'd think an oral hearing would be fair. But is this not quite a different test? It's totally objective. Is it proper when, is it reasonable to think that somebody might be biased when they're being attacked for something they've already decided?
Well, with respect, my Lord, it's attack for something they've already decided. That applies on the question of a merits issue, because they're going to be attacked on something they've already decided. With respect, I don't
It's not
think
quite
that
the same,
quite
because here
answers
he
the
set the procedure.
But well, my Lord, again, this is, we say, the fallacy that Mr. McGrath says, oh well, this was all set by Lord Justice Flaux, but he was just presented with the position. Didn't mean he couldn't rule on whether or not what he had then been presented, and he had made his decision off the back of that he was going to be biased in relation to dealing with that issue. It's not like
it might be said that it's one thing for a judge to listen to a submission that he got it wrong, and another for a judge to listen to a submission that he has personally been unfair.
Well, I would, with respect, beg to differ. I would have expected, with all due respect, my Lord, that if a judge is going to be said to have been unfair, he will be even more careful, or she will be even more careful, to deal with it properly. and with an open mind.
These sorts of psychological speculations are the real reason why it has to be why the test of recusal has to be entirely objective. You can make all sorts of arguments, as you say. Sometimes a judge may sort of bend over backwards when to avoid, but you just get into the weeds if you make those sorts of submissions. The fact is that he is being criticised for decisions that he made about how fairly to handle the procedure. Wouldn't the fair-minded observer say, I'm not sure he'd be able to come to it dispassionately? There's a risk he wouldn't be able to.
Well, with respect, I would also throw into the mix there, Noel, that a fair-minded, informed observer would, in my submission, take on board the fact that the other side did not pursue the recusal with Lord Justice Flaux at the hearing. When I am present and able to comment on and or take the issue further forward, and Lord Justice and the parties then know the basis upon which Lord Justice Flaux says, no, I am able to deal with this, and why. And I take the point that your lordships are not attracted by that submission, but we do say that it's a very strange situation whereby it can be raised, this complaint, in a skeleton that it's not dealt with properly and openly.
Well, we're going round in circles.
Yeah, I know, my lord.
We've got that very clearly on board, but that is really an earlier stage.
My lord, the only other...
I mean, I think the good thing, Mr. Davies, is we are pretty well agreed, I think, or you are pretty well agreed as to the process we need to go through in deciding the issues, and that is we decide the recusal first, whether he ought to have recused himself in all the circumstances between basically 28th of September and the 11th of January, bearing in mind the fact that the application was not made, as you say, or was made, as Mr. McGrath says, we have to determine that. And then we move on. If the recusal is decided in Mr. McGrath's favour, we then come to consider 5230 in its full glory again, on the premise that there still has to be some inadequate undermining of the procedure, followed by a real possibility of success on the appeal. So that process we're not really at odds on, as far as I can see.
No, I don't think so.
And you say, as I understand it, that they're not pursuing the recusal sort of comes in to both stages.
And it does, my lord, and also, I mean, do not lose sight with respect of the delays.
And delay comes in
continually faced in relation to this case. I mean, those are important points on.
No, the delay.
Especially when you take into account that usually you have 21 days in which to issue your permission to appeal. The other side don't seem to really pay heed to.
Not a year like you used to have,
Yeah.
which I'm astonished
Which
by.
we learn. Yeah, we learn, late at night reading Lord Justice Saville, as he then was.
Yes, Lord Justice Saville, and fascinating because it was back in 1883. I mean, they took a leisurely approach to litigation in those days. And then, of course, you've put me in mind also of all these striking out for want of prosecution cases that we used to do I used to do when I was young, when delay was, absolutely axiomatic in every case.
Yeah, and it's, and we say in this instance there is no excuse.
No, you say it's ridiculous, but they do say, well, we had to prepare ourselves. There's very serious application and so on.
Well, just sorry on that one point, my lord. I should say there's this issue taken by my learned friends. Say, oh well, we did our 3.3 application on the 30th of July, 3.35 application. But we didn't do the 5230 application because it was a very serious application and what have you. But the basis of that 335 application in terms of the factual basis and the arguments on Marex were exactly the same that appeared in the subsequent application, which is a point Lord Justice Flaux picks up on in his judgment.
Yeah, and the judge had directed them to issue it.
Correct. And whilst I haven't dealt with all of the 4 points, but the timing point, I think my learned friend says, well, we were only given 1 day in which to issue. Well, they managed to do that on the 335 application, and they could and should have done it on the 5230, what we say. And in any event, as I think my Lord Underhill has pointed out, it didn't actually make the difference. Although it was referred to by his lordship, he did actually give them grace. It's not like he shut them out when they did serve the application late. I should also raise a point which, before I sit down, is we have put in our own witness statement in response to this, showing the extent to which the parties have acted upon finality
in the Isle of Man.
In the Isle of Man, my lord, and the fact that we have been making distributions as a result of the fact that these proceedings we thought were at a conclusion. Now, how that is going to impact on us and third parties, I have no idea if this is all now going to be unwrapped. I don't know if your lordships want me to take you to those references just to show you.
Well, just give us the name.
It's basically paragraphs 16 and 17 of Mr. McCauley's second witness statement,
That's right.
which are at tab 10, pages 479 to 482.
Yes. I see that the hearing was on the 3rd and 4th of March, and the parties are awaiting judgment still.
I think it was May, my lord. March. Oh, it was March, and I think we are still awaiting judgment.
Perhaps
I mean, that's quite an involved bit of procedure on the Manx proceedings, but the basic point is that those proceedings were stayed pending the conclusion of these proceedings. And when we had Lord Justice Flaux's decision back in January of last year, the result was that the Manx proceedings were able to come back to life, and both parties acceded to that, so the stay was lifted. And the relatively minor issues that were argued about, we're still waiting judgment.
You did say that the UCP had made distributions, but I'm not sure that's what Mr. Macaulay says in paragraph 17. Does he? 17C says, but for the continuation
B, I think it's B.
of these proceedings, UCB would have been in a position to consider, etc., regarding distribution and recoveries.
Well, no, in B, my lord, it was...
distribution announced and made, yes.
Sorry, I was looking at the wrong paragraphs. Just
Paragraph 17B. 16, I think, deals with the Manx proceedings, my lords, and 17 is dealing with the distributions issue.
Yes, I see.
And of course, the longer these proceedings drag on, the longer we're unable to wind up UCP, which is not really not trading at all.
Yeah.
The way you put it, though, I'm paraphrasing, I can't remember exact words, is it's really anyone's guess what impact this will have, the fact that you have begun to make distributions. Isn't it quite important that you say what impact it will have? Because you're asking us to do something which on this hypothesis would otherwise, not to do something which on this hypothesis would otherwise be just, because of the impact that would have as a result of the delay. Don't we need to have that absolutely pinned down, what that process is? I certainly haven't got any clear impression of it from what we've been told. Maybe my fault.
Well, no. I mean, the fact of the matter is that distributions of monies have been made out to third parties on the understanding that these proceedings have concluded. Now, if the position is that it's to be reopened, I don't know what I can't say to your lordship.
Well, knowing a bit about insolvency, it's unlikely that distributions will have been made on the basis that you were going to recover from Nectrus, because you haven't recovered from Nectrus, and liquidators generally only make distributions when they've got the cash.
No, my lord, well, we do recover from Nectrus because they are a shareholder in UCP.
Yes.
So we take from what is to be distributed to them. So we do have monies that we...
So it's circular?
Yes.
Okay. All right, anyway.
But they're only one of the shareholders. I mean, the other...
Third parties have had some money.
Pardon?
Third parties have had some money.
My lord, yes.
Okay.
And I don't know, so far as I don't know the present position with regard to Nectrus. They seem to be able to continue to fund their legal team, so there are obviously monies somewhere.
That would seem to be the case.
Very reduced.
My lords, unless there's anything else you wish from me,
No, thank you very much, Mr. Davies. Very helpful. Mr. McGrath.
Lord, on that, the point about distributions, as we read the chronology that was agreed between the parties at tab 20 at page 794, the last distribution was made on the 30th of October 2020, so some time ago, and we would echo the observations of Lord Justice Underhill that there's no sight on exactly how much aware distribution and what impact and who might be, if any, prejudiced by that. And whilst we're not in the Middleton scenario, one would recall from that case that there was a keen interest in establishing any clear prejudice by way of evidence to be provided in order for that fact to be properly considered.
I mean, if that had been the case, it would have been or could have been considered at the first 5230 hearing.
My lord, yes, because obviously that was in January 2021 and the last distribution was made several months before that. So that would have been fine there. Lord, on the question of delay, we would say that it would have to be tremendous delay to outweigh any serious injustice that we say arises here. So if we otherwise would get home on 5230, we say that the period of delay, whether in the first application or the second application, is not so material as to be a factor that would result in a contrary decision. My Lord, we do say that, and I'm not going to press the point, but when one looks at the chronological run of the correspondence between ourselves and the Court of Appeal, and then the 3rd of November indicator from the judge, that a decision had been made against us. And it's in that context in which decisions rightly or wrongly were made not to make a further attempt in front of the judge and thereby start our serious application off on the wrong footing from somebody that had clearly made up their minds already that they were to hear the case. My Lord, the Master of Rolls brought up 5218, and my Lord, I'm not going to suddenly jump on a horse that hasn't been ridden this side before. I think that's not appropriate, although it perhaps is just a reflection of, frankly, a bit of a dog's dinner that this whole exercise was, and that had things been done properly through, and the question of fault your lordship raised, well, ultimately one needs to say natural justice. Do we need to ascribe blame, or do we just say that one party wasn't given a fair opportunity? No one needs to say that the judge made any deliberate decision to shut the door on the right to put in further submissions deliberately or anything. All it needs to be is an unfortunate misunderstanding based on his reading of the letters. But that's a misunderstanding which seems to go even further if one adds 5218 to the pot. Because at that point, then the application, if the letters are to be treated that way, would be by my friend, the second of the letter, and we clearly didn't have a chance to respond to that. And I've addressed your Lordship on the point about the criticism of not responding between the Tuesday and the Friday, 21st and the 24th, being somewhat unfair in circumstances where we had not been indicated that that was something that we had to do, and that was in the mind of the judge at the time. And my friend prayed in aid the fact that the judge wasn't a mind reader of what we were thinking. The killer critical issue is what the judge was thinking, and I put the point against my friend to say that we're not mind readers of the judge either. So how he perceived our letter, their letter, and the correspondence, we simply didn't know and weren't informed. And it could have been dealt with quite easily. We've had 2 letters. Is that your last word? Or Nectrus, I want you to reply by, 2 or 3 days. And that did not happen. I've dealt with the request issue, so I won't do that again.
When you say the request issue, what do you mean?
The criticism that when my friend was talking about the original PT, the second PTA decision, that we, the judge, criticised us for having failed to request more time for submissions.
Yep,
and I've addressed that, I think, ad nauseam on that, and so that I know it's one side saying somebody else should have done something, but at the end of the day, I will say, although my friend has indicated that it's the responsibility of Nectrus, that at the end of the day, the case management of any application, formal or informal, the responsibility lies with the judge. That responsibility was emphasised in the CPR. That control was given so that a more proactive, involved relationship between the judge and the case was to be invoked. And it cannot now be right to abdicate responsibility on the basis that the letters written in the abstract weren't as clear as they could be. That's just not fair criticism of my clients. I've accepted that if you are in looking at the letter, does it make an express request clearly? I've said no, although I think a fair reading of it would suggest that there was plenty more to be said if you were with me.
Well, it refers to a revised skeleton argument to deal with Marex directly.
My Lord, yes. And my friend said if you're not with us on dismissing it on the basis of the letter, then there needs to be a revised skeleton on our side and maybe given an opportunity to put in a revised 3-pager in response. Well, we don't accept that situation like Lockavale can be equated with what went on here, principally for the reasons that Lord Justice Underhill indicated, because we had already raised the issue. It's not a question that the judge has disclosed something and we've kept it up our sleeve. And in fact, we've been invited by the judge to respond if this is going to cause any trouble, and haven't indicated that it would cause any trouble. Now, that can't be equated with a situation in which we did from the outset say, no, we want a different judge, and explain why. So we didn't just say we like a different judge. We actually pointed them to the skeleton and the 2 paragraphs from the outset. And the attempts to suggest that the judge didn't read it, well, I think that doesn't carry my friend any further. And if it was true, it carries me a lot further on this application. And so, my Lord, unless I can help you any further with any of the points.
I just feel a slight need to tie up a loose end because I may have said something that wasn't quite right. I don't think it will have misled anyone. But I've just been looking at Part 23 in this question of when a formal application is required. And the position seems to be that the White Book notes distinguish between an application and a request, that they don't explain the distinction, but sometimes the rules do themselves refer to a request. But if it is an application, it must be made by an application notice, unless the rules provide otherwise, or the court dispenses with it, and there are some particular rules which say you don't need an application notice. But an application notice doesn't have to use the prescribed form as long as it does the essentials, which are spelled out, which effectively say what order you're asking for and why, with a statement of truth if appropriate. Frankly, I'm not sure any of that matters, but I didn't want to have summarised the point inaccurately and then had the parties so we didn't understand.
Well, there's just one point. My friend didn't push it, so I'll deal with it extremely lightly. On the third criteria of 5230 alternative remedy, I don't know whether there's a tweak in the tail, it was suggested that the possibility of suing for not having drafted a clear letter represented an alternative remedy.
Suing for what?
Suing the Nectrus suing its own lawyers, not having drafted a clear enough letter. And I believe that's an idea that has credence from the, I'm going to try and pronounce it, Caridian case of Chancellor. But in that case, there were professional advisors who advised the directors to move money into pensions, and that was a breach of trust. And so the issue of the ability to recover from the advisors was not one that was before the court on the 5230. Here, the question of the clarity of the letter, which I've been addressing you on both this morning and just a moment ago, is a central question to the entitlement to relief under 5230. And it's a very unpalatable suggestion of satellite litigation, and one that we would certainly reject.
What is an alternative remedy as opposed to an alternative course of action? Of course you could sue your solicitors, but is it a remedy unless you actually get something out of them?
Well, I think that this hair was started running by the Chancellor in that recent case, but I'm just saying that it doesn't apply here because the concerns relate to the very issues that are before the court on the 5230. And so you can imagine who should go first.
Becomes quite circular.
It does, yes. Well, that's all I want to say, but my friend hasn't pushed that.
Thank you. Well, thank you all for your submissions. Thanks to your solicitors too. We will take time to consider our judgments and hand them down in the usual way. When we do so, you may use the judgments only for the purposes of agreeing direction, an order and costs and disposal, but you must not use the judgment for any other purposes, you will now know, and I hope that we will already have been informed to whom to send the judgment, because we do like to know precisely who is going to get the copies, but subject to that, obviously we won't have a hearing on hand down or anything else, and you'll agree consequential directions in writing, unless you can't agree, in which case you will make submissions in writing and they will be decided on paper. So I think that concludes the hearing, with thanks to you all.